Hey guys, welcome back to the channel. This is the House of Law and I am Attorney Al Jumrani. This is episode 5 of Civil Law Jurisprudence by Justice Leonen. If you missed the 4th episode, you can watch it through the link above or the link in the description box below. In this episode, I will talk about 3 more Supreme Court decisions penned by Justice Marvic Leonen. The first case is about rescission of contracts. The second case is about an innocent purchaser for value. And the third case is about the character of roads and streets in private subdivisions. By the way, a few days ago, I posted this book and asked you to comment why you want to become a lawyer. Thank you for all your warm responses. Although I said I will choose the best comment, I cannot find the best because they're all the best. So I have decided to choose the lucky subscriber by raffle. So watch till the end of the video to know who's the lucky one to get this book. Alright, let's begin. Our first case is Wellex versus Airlines, GR number 167519, January 14, 2015. Wellex Group Incorporated, a Filipino corporation, and Airlines, a Taiwanese corporation, entered into a memorandum of agreement as a prelude to a share purchase agreement, whereby the latter will buy shares in Wellex so that both can engage in the aviation business in the Philippines. Uland paid more than $7 million for more than 1 million shares in Air Philippines and 450,000 shares in Philippine Estates Corporation, both of which were owned by Wellex. No share purchase agreement was executed by the parties, however. So, Uland filed an action to rescind its agreement with Wellex to recover the $7 million. But Wellex refused, saying that for rescission under Article 1381 of the Civil Code to prosper, there must be economic disadvantage or prejudice. In this case, the $7 million, according to Wellex, were properly valued as price for the shares to be purchased. So the issue in this case is whether Uland is entitled to rescission and whether it's Article 1191 or Article 1381 that will apply. So here the Supreme Court held that the failure of one of the parties to comply with its reciprocal prestation allows the wrong party to seek the remedy of Article 1191. The wrong party is entitled to rescission or resolution under Article 1191 and even payment of damages. Article 1381, on the other hand, pertains to rescission where creditors or even third persons not privy to the contract can file an action due to lesion or damage as a result of the contract. Under Article 1191 of the Civil Code, the power to rescind obligations is implied in reciprocal ones in case one of the obligors should not comply with what is incumbent upon him. The injured party may choose between the fulfillment and the rescission of the obligation with the payment of damages in either case. So Uland is seeking rescission and restitution what it had paid on the ground that the share purchase agreement did not materialize. This case does not involve prejudicial transactions affecting guardians, absentees, or fraud of creditors. Hence, rescission under Article 1191 of the Civil Code is proper. The second case is Florentino, Leong versus Edna C, GR number 194077, December 3, 2014. In this case, Florentino Leong was married to Carmelita Leong. They used to own a real property in the Guzman Street, Quiapo, Manila. In the early 90s, they migrated to the United States and there they dissolved their marriage. In their marriage settlement agreement, they agreed that Florentino would waive his rights to the property in Quiapo, Manila. That property, however, was being occupied rent-free by Edna, Carmelita's sister. In November 1996, Carmelita sold the property to Edna C. Title to the property in the name of Florentino and Carmelita was subsequently cancelled and a new one was issued in the name of Edna C., the buyer. Now, Florentino questioned the sale, alleging that the sale was without his consent and that Edna was not a buyer in good faith because she knew that Edna was in actual possession of the property. Edna, however, countered that she did not only rely on the clean title, but also verified the authenticity of the waiver signed by Florentino and made personal inquiries at the Manila Register of Deeds regarding the seller's title. So the issue in this case is whether Edna was an innocent purchaser for value. What is an innocent purchaser for value? Well, an innocent purchaser for value refers to someone who buys the property of another without notice that some other person has a right to or interest in it, and who pays a full and fair price at the time of the purchase or before receiving any notice of another person's claim. In this case, the Supreme Court affirmed the uniform findings of the trial court and the Court of Appeals that Edna was an innocent purchaser in good faith for value. As discussed by the Court of Appeals, Edna did conduct further inquiry by relying not only on the certificate of title but also on Florentino's waiver. As to who between Edna and Elena, who was then occupying the property rent-free, has a better right, the Supreme Court held that Edna should be preferred because Elena's possession was neither adverse to nor in the concept of owner. Our third and last case for this episode is Republic versus Spouses Francisco Llamas, GR number 194190, January 25, 2017. So in this case, in the early 90s, the Department of Public Works and Highways, or DPWH, expropriated several properties in Parañaque City for the widening of Sucat Road. One of the affected property owners were the spouses Llamas. They claimed that 3 of their properties were affected, namely Lot 4, covered by TCT number 217167, Lot 1, covered by TCT number 179165, and Lot 2, also covered by TCT number 179165. The Regional Trial Court, which was trying the expropriation case, however, ordered that only the portion of Lot 4 covered by TCT number 217167 should be compensated. The court noted that the other properties were subdivision road lots, which the spouses Llamas no longer owned and which belonged to the community for whom they were made. On appeal to the Court of Appeals, the appellate court ordered DPWH to pay just compensation for the other 2 lots. It reasoned that the disputed properties did not lose their private character. It must be noted that in this case, the spouses Llamas were owners or developers of a subdivision. Under the law, they were required to provide open spaces for public use such as roads, alleys, and sidewalks. Thus, the issue in this case is whether these subdivision road lots are already public in character and are not entitled to just compensation when so taken for public use, like the widening of a public road. So to this, the Supreme Court ruled that delineated roads and streets, whether part of a subdivision or segregated for public use, remain private and will remain as such until conveyed to the government by donation or through expropriation proceedings. An owner may not be forced to donate his or her property even if it has been delineated as road lots, because that would partake of an illegal taking. The owner may even choose to retain said properties. So in this case, the spouses Llamas have not made any positive act enabling the city government of Parañaque to acquire dominion over the disputed road lots. Therefore, they retain their private character. Accordingly, just compensation must be paid to the spouses Llamas as the government takes the road lots in the course of a road widening project. Alright guys, those are the 3 cases for today's episode. Before I end, as promised, I'm going to choose one lucky subscriber who will receive this book. There were 21 very inspiring comments and it was difficult to choose the best among the best, so to speak. Kaya iraraffle ko na lang para fair. Are you ready? Let's start the draw. Yay! Congratulations to Criseline Nicole Moyalde. Please email me your complete name, address, and telephone number so I can send this book. Please email the details to jumranilawoffice@gmail.com. Alright? So sana mag-email ka na agad para mapadala ko sa'yo. So that's it for episode 5 of Civil Law Jurisprudence by Justice Leonen. I hope may natutunan kayo today. For the bar reviewees, take note of these cases. Baka lumabas sa bar exams this November. Again, congratulations to Criseline Nicole Moyalde. And to everyone, please drop a like if you like this video. Please subscribe to support me, and please ring that notification bell to be alerted when I upload a new video. So till the next video, laging tatandaan, isip ay buksan, alamin ang batas. Bye guys!